Thanks, good people. How are you, good people? I'm good. I hope you guys are good. Welcome to another episode on the platform, the labor lens. Today we are talking about the arbitrator's aggressive questions appears to indicate bias, right? You know, people go through these things, right? Go through these things either as an employer or as an employee, right? Where you've got a matter where you've got to answer to, or where you are the referral party. Then, of course, there's an arbitrator who's arbitrating on issues. The conduct of the arbitrator comes into question sometimes, right? Because people always say, but this arbitrator was biased against me and all of that, right? Let's just understand in terms of the conduct how the arbitrator conducts himself or herself, right? Okay. An employee, right? An employee was dismissed for alleged misconduct, right? Involving bribery, corruption, and dishonesty. The CCMA commissioner ruled that his dismissal was unfair and he should be reinstated with back pay. The employer then alleged that the commissioner had committed gross irregularities during the hearing and sought to have the award reviewed. Right? The case we're talking about the South African Revenue Services versus the Commission for Conciliation, Mediation and Arbitration, which is CCMA, and others. Right? That took place on the 3rd of April 2023. The case summary. SARS filed an application to review an arbitration award which ordered the reinstatement of Francos Allens, an investigator who was dismissed for alleged misconduct involving bribery, corruption, and dishonesty. Commissioner Parathi Petha found the dismissal to be substantively unfair and ordered that he be reinstated with back pay. The transcript of the aggressive line of questioning by the commissioner during the hearing clearly shows that she was trying to tease apart the two disparate accounts of the events, but in her efforts, she acted more like a representative for one side than an arbitrator. The applicant was dismissed for misconduct on charges of bribery, corruption, and dishonesty. The respondent alleged that the applicant had called a David Hans and had asked him to look the other way when inspecting a container, and if he did so, he will be well compensated. The applicant acknowledged that he called David Hans on 15 September 2017, but denied offering him a bribe in exchange for looking the other way. Hans testified as a witness, stating that when he inspected the container, he found undeclared goods, including counterfeit goods, to the value of about 10 to 12 million rands in that container. The commissioner tried to impress upon the witness the gravity of the accusation he was making, because his statement included the belief that the entire organization was riddled with corruption. She tried to make it very clear that beliefs can taint one's perception of events, and in that instance, exact words are more important than general beliefs engendered by rumors. Her summary of Hans' evidence reads as follows. Quote, the respondent then called their only witness, who had first-hand knowledge of what had happened. However, this witness was very unreliable. Without even being prompted to do so, he revealed prejudice that he felt by his belief that everyone who came from TIU, Tactical Interventions Unit, were corrupt. Prior to the hearing, he had reported that the applicant had called him on 15 September 2017 and asked him to ignore most of the contents, right, of the container, and in exchange he will be taken care of. He then called his manager to report the phone call. His manager then told him to unpack the entire container, whereby he found bales of counterfeit goods. Under cross-examination, he admitted that he did not really hear the applicant on that day because the call was only for 1 minute and it was very noisy where he was. He then drew his own conclusion that because the applicant worked at Tactical Interventions Unit, his call must mean he must overlook certain goods and he will be taken care of. In perusal of the appeal application, it appears as if Hans did not come across as being a reliable witness at the disciplinary hearing himself. According to the court, the prejudice against TIU was proffered by Hansen in an answer to questions by the commissioner. She appeared intent on obtaining an answer from Hans to the effect that it was because of this prejudice that he had thought the call from aliens involved corruption. The commissioner's repeated warnings to Hans that a man's life was at stake and her insistence that he go and think carefully about his version strike the court as unusual, intrusive in far as the proceedings were concerned. Her interventions were made both before he was cross-examined and after he was re-examined. An arbitrator is required, right? An arbitrator is required to conduct the arbitration fairly and quickly, dealing with the substantial merits of the disputes, with the minimum of legal formalities, while striking an equitable balance between formality and fairness. The court may intervene in terms of its supervisory functions if it appears from the record before the court that one of the specific grounds as listed in section 145 subsection 2A of the Labor Relations Act actually exists. Although the commissioner may conduct arbitration proceedings in any manner deemed appropriate, the commissioner cannot become engaged in the proceedings to such an extent that it appears as if he or she is a representative of one of the parties. The conduct of the commissioner must respect the roles of the parties' respective representatives, and the commissioner cannot assume to herself the role of leading evidence and conducting cross-examination. The court noticed that arbitrator had repeatedly warned the witness that a man's life was at stake and had asked him to clarify his memory of the facts both before and after his testimony. She interrupted the representative for the witness and interpreted the words of the witness before he had even finished speaking. All in all, the court found that the arbitrator had not conducted a fair and impartial hearing of the issue and had overstepped her bounds. It was ordered that the award be set aside and that the case be heard afresh by a different CCMA commissioner. No order was made as to cost. Thank you very much, guys, for tuning into this channel. I hope you learned something, right? I hope you learned something. Please remember to share this video, right? Share this video so wide as possible to ensure this kind of information reaches people who may need this kind of information, right? And please remember to subscribe to the channel. On the subscribe option, please do click on the subscribe option to become part of the channel. Let's grow this community, let's grow this audience whereby we empower each other about the labor relations in our country. Thank you very much, guys. Remember to like, share, subscribe, and comment. Siyabonga kakhulu ma-Afrika mahle.